Today I want to talk to you about trademark law. There are three main types of trademarks. There's regular trademarks, service marks, and an area called trade dress. So what is a trademark? The terms trademark and mark are commonly used to refer to both trademarks and service marks. Trademarks specifically are any word, name, symbol, device used to indicate the source of goods and to distinguish those goods from the goods of others. Whereas service marks identify the source of service rather than a product. So why do we have trademark law? Well, one, we want to have quality control, and we want to make sure that the goods that are being produced and labeled are actually quality. And this helps protect from consumer confusion and from unfair competition. So those are the three main reasons why we have trademark law. It's really for the protection of the consumer, so that there's quality products that you can identify the source of goods or services from. We classify trademarks into 5 classifications. The lowest or weakest marks are considered generic, and the strongest marks are considered fanciful or arbitrary. So generic marks are the weakest and have no protection because they're the generic name for a product or service. A little bit more protection are descriptive marks, which describe the products or service. Then a step above that is our suggestive marks, which kind of suggest the quality or nature, and it really requires the consumer to do a mental leap and requires some imagination. Now, the strongest marks, as I mentioned, are arbitrary and fanciful. Arbitrary are real words, but they're not used in connection with the meaning. Fanciful marks are made up words that are not, they're not found in the dictionary. You made them up. So I'm going to go through some examples of these 5 classifications. As you can see, fanciful trademarks, there's Clorox, Exxon, Pepsi. These are made up words and they're very strong because they're made up words. They're not going to be used in common language. Arbitrary marks, there's Apple is the most famous one. Apple, they make computers. Apple's a common term, but it's not connected with the goods of computers. And Dove, obviously, is a bird, but it's connected with soaps. So these are arbitrary ways of using words in a trademark sense. Some suggestive marks are either Burger King or PlayStation. For example, PlayStation, it gives a mental leap into what it is. It's a video game station device. So there's some mental imagination going on. Another good example would be Microsoft, that they produce, computers and software. Some descriptive trademarks, descriptive trademarks describe a feature or quality of the goods or services. So like American Airlines describes their service, and Play-Doh describes their product. Dough that you can play with, or an airline based in America. And then generic trademarks could be any generic term, for, let's say, app for apps. There's Apple for Apple, T-shirt for T-shirts, debit card for debit card services. These are all going to be generic marks and won't have any protection. And this is derived from First Amendment protections. Now, trademarks can become generic over time and lose protection if you're not enforcing your marks and protecting it as it's being used in the marketplace. So common examples are Kleenex and Band-Aid, aspirin's another good one, Tupperware. These all started as strong trademarks, but because people used them in common day language over a period of time, they've become what's known as genericide. They become generic. Now there's, like I mentioned earlier, there's difference between federal and state protection in trademarks. State protection is generally weaker because you're going to be restricted to only your existing geography, whereas federal rights, it provides to the entire United States. Uh, and to get a federal trademark, you must use the mark in commerce. And if you're not using it, there's an option to file an intent to use, where you're going to be showing use of the mark, typically within 6 months, but in the near future. And then only the granted federal trademarks, can use the registration symbol with the circle. So those are, some of the difference between federal and state protection. Now, an area of law under trademarks that you as a startup should consider is trade dress, especially if you're using packaging or products or presenting your goods in a certain way. Trade dress protects the whole appearance or visual image as it's presented to the customers. And this could be like the shape and appearance of a product, the shape and appearance of a container, the layout of a restaurant, cover of a book or magazine. You can get pretty creative with this, and I'm going to show you some examples. So as you can see, these are some trade dress examples. You can see the layout of the restaurant, famous Jack Daniel's bottle, very familiar shape of the Coca-Cola bottle, and as well as a smartphone. I believe that's an iPhone. And that is trademark law.